Meta and Alphabet are on trial in Los Angeles this week, facing allegations that the design of Instagram and YouTube leave young people addicted to those apps. Joining us right now is Anish Chopra. He is former White House chief technology officer during the Obama administration. And Anish, we've been speaking for several years about what to make of the social media companies, where things stand, what government has done well, and where government has not done a very good job. What do you think of this trial? It's being likened to the big tobacco cases of the 1990s. How significant do you think it is?
Well, it's a blunt instrument to bring accountability on these concerns that social media overuse results in potential mental health issues for kids. I'll say that we have a bit of a mixed policy history here. The original Section 230, which provided a bit of that protective liability shield, also included a provision asking for the social media companies to responsibly self-govern. We can probably all agree that maybe just, hey, will you give it your best shot? Didn't quite work. We did try about a decade or so ago to bring more multi-stakeholder collaboration to get to these voluntary agreements, but that didn't seem to move the needle. So we're at a place now where if the social media companies don't get their act together and move forward, they're going to face these blunt instruments or really regulatory challenges like in Europe with the Digital Services Act. And so it's kind of on them to want to work closer together or else face these sorts of more blunt instruments of accountability.
The social media companies will say, hey, we are doing our best. We're trying to make sure that we are policing this more. Other people will say, hey, it's the parents' fault for allowing kids on social media. How do you take those arguments?
Well, let's peel the onion back a layer. I mean, what we're really saying is that the feeds we're seeing today, at least the accusation is, their algorithms are maximizing engagement, which is encouraging more use, which is encouraging some of the behaviors that result potentially in mental health harm. So those are active choices that the platforms are making. And we're seeing a bit of a split. If you remember, X has made a slightly different move. They've published the algorithm for their For You, so you could actually have third parties evaluate whether they're doing particular things to kind of bump engagement. So that's transparency at a level that others haven't yet replicated. And they're giving you algorithmic choice. For those of you who look at your X feed, you can either do the For You or you can do following, which looks more like a neutral timeline feed. And so those are steps that are different than the traditional social media tools that perhaps our kids use. And that may be an area where we can see some divergence and really a legal interpretation as to whether or not you're simply a neutral editor if you don't offer these options, or you're actually an active product designer that has made conscious decisions that could potentially put people in harm's way. So that's a difference now in where the industry is operating, and hopefully with enough pressure, this could result in some collaboration.
In Australia, they basically banned these accounts for children under the age of 15. Do you think that's the right move?
I think these are blunt instruments. And so if you go back, I mean, even in President Trump's executive order on AI preemption, there's actually a carve out to say, look, we still need to solve problems like online safety for kids. And so states are allowed to kind of innovate here. What we need to understand is when you've got a new technology that is potentially filled with great joy and promise, and we're going to solve a lot of problems in the world, and I'm an optimist, right? That's my background. We also have to find ways to get the industry to work together on enforceable codes of conduct that are easier to adjust than changing laws or regulations that are really difficult to move. So we've got this trade. We want the innovation, but we need enforceable codes of conduct, and it's better to be organized by the private sector with, stakeholders around the table, thoughtfully evaluating the micro decisions about what is too far, what is just right. And that just is a different DNA. And I think you've seen the frontier models take a step in this direction on safety. And so maybe we could get the social media companies to think about that more on the online safety for kids specifically.
Why is this so hard to get anything past Congress? I mean, some of these seems pretty simple. I'm not talking about doing what the French are now threatening to do, which is following Australia's ban for anybody under the age of 15. But why has it been so difficult to get even a baseline of protections for children's built in on a federal level?
Let's take the European Digital Services Act, and they've got very strict, detailed regulations on what you have to do, which is obviously a big part of the non-tariff trade barrier discussion with the Trump administration. When you have blunt language in the law around technical features, inevitably they're going to be a little bit outdated and subject to a court interpretation anyway. So if you're thinking about this trade-off, we're looking for Goldilocks, okay? Not too hot, not too cold. What we're looking for is, you don't want the industry to say, hey, please try harder. That's not good enough. You don't want to be blunt, because then you're sort of potentially constraining innovation and adding this sort of regulatory tax. What you really want is responsible governance with stakeholders. And so that's hard because Congress can't say, please work together on enforceable standards. You kind of have to set that as a norm. And this is not a lot of stakeholders that need to get around the table to do this. And so maybe if the trials go and we have months and years to go to figure out where these particular ones land, hopefully there'll be another catalyst to drive action that speaks to that Goldilocks middle. Because otherwise we want to be an innovative economy in the United States, but we want to have responsibility at the pace of innovation. And that can only be done through sort of voluntary enforceable standards.
Yesterday, TikTok settled this case, so it was taken out of the lawsuit. Previously, Snap had settled. What are the odds that the other two major players end up settling, or do you think this is going to trial?
This feels like a category, Becky. I don't think this is a single trial. Like, we got state attorney general coming. So I think it's, at the end of the day, we're going to have to set norms. And, again, I just point out X has gone a certain direction and the other platforms haven't, and maybe there's a path to replicate. Because I'd rather, like in the Australia analogy, I'd rather there be choice to the consumer, an informed choice, than a blanket